what makes it easier for me, as I have a small budget. I really want to focus on building the app. I really want to focus on building an experience and offering hopefully new customers that experience. So I don't want to focus on all the other stuff, that legal stuff, IP protection, hunting down maybe even IP infringing apps on some other alternative marketplace or somewhere on the web, because, well, it's easier to just ask Apple to do that on the App Store and protect me in that way. So what you see right now is that the market is fragmentating, which is going to cost me extra money to try and get those customers to my attention, and also potential higher legal bills to enforce IP protection. And also, like, maybe one of the fundamental thing is that we are living in an age where people actually trust their devices, their Apple devices, their Android devices, to protect them through security features like the App Store. So with that trust in those platforms, they also trust me as a third party somewhat. Like, it's a sort of perceived trust in me as well, because they feel protected by Apple and Google and the respective app stores, which makes it easier for them to make that decision and say, like, yeah, I want to try that new experience. That is actually quite novel in the computer space, if you ask me. At least that's my experience. Yeah. Thank you.
Great, Mitchel. And César, do you want to ask Mitchel some questions right now, or you are muted?
No, as Mitchel has said, in some sense, it's good for him to be in an umbrella of Apple or other app stores, because he's small. So differently from what we usually think about, is that he's very small in a very big structure, and perhaps he will be smashed by this structure. But he's no, it's the other way around, because there are a lot of costs to being protected, like IP issues, that I don't need to make actions, because they are very costly if I was by myself. But I'm not by myself, so it's really the opposite of sometimes what we think. Like Rafael perhaps can confirm about this, because he's recently working before the competition agency. But it's the opposite that we usually think about on antitrust matters. Could you say more about this? To being in a huge umbrella, being protected and being small. Mitchel.
Sorry, I thought you were asking Rafael, but yeah, for sure, 100%. This is exactly what I experienced, and what I notice is that the companies that may not need that, these are bigger companies that are, well, maybe advocating for regulation like this. I understand, because they have an easier time handling that. They have a legal team. They have an entire infrastructure that can help them do what Apple is essentially doing for me. It's providing, small business owners like myself. So yeah, actually, it is the opposite for small businesses like myself. Yeah, 100%.
Yeah, and when we see the movement to allow side-loading apps, it's that we have in Europe. I think that there's a recent process against Apple, maybe that they opened it recently about this. We can think about the security of the consumers, that you can be jeopardized by that kind of thing. So it's very interesting, this perspective. Now, Morgan, I would like to know, what do you think are the roles that platforms play, and how does DMA change this ecosystem that developers, consumers, and platforms all rely on? And how do you think we in Brazil can balance this need for regulation with the need to foster innovation within its digital economy?
Thank you very much for the question. And I thought Mitchell outlined many of the issues in his statement. But I think what's really interesting is we are talking about Apple and Google and Microsoft and others as umbrellas or shields. But really what they are is suppliers to us. They supply customers, they supply services, they supply trust, and we pay for it. It is a service that small businesses get from these. So what I like about the current ecosystem environment is two things. One, they are motivated to do things for small developers because that keeps the platform vibrant. Right now, there are 1.7 million apps on the app stores. Google, roughly 2 million apps on the app stores. There are hundreds of thousands of developers from around the world. I'm older than Mitchell. I remember in the days where when you made software, it came in a box and you had to go to a store to buy it. And it took a year to get it on the store shelf. These competing platforms, these bigger platforms, are providing me services that allow me as a very small business to put a product into the hands of millions of people without having to pay for printing a disc, hiring an attorney to do my taxes in 52 countries, handling my intellectual property, spending millions on branding because no one will give me money if they don't know who I am. Now I am paying for those services from the bigger platforms. And so when you read the quote from Versteyer, small software companies have never had more opportunity than they have today. And how do I know this? 1.7 million apps. 1.7 million apps. There were never 1.7 million boxes of software on the store shelf. So we have had an explosion of opportunity. And I think what Mitchell talked about, which is really important, is it allows me as a developer to do one thing really well, to make an app that solves one or two problems better than anyone else. Or maybe it's a game that has one fun element or two fun elements. And yet I can still find people globally who want to play my game or use my product. And I think that's why I always break it into the three things we need from platforms and why I think the system can be healthy the way it works now. Because we need to offload overhead, I say, the taxes, international taxes, the IP protection, the idea of credit card handling, all of this stuff. I don't want to worry about it. I don't want to collect people's credit card information and have it on my computer, so I can outsource that. That's part of it. The other part is I need access to a global market. So if I am in Brazil and maybe there are 10,000 people in Brazil who would buy my app, if I can sell to 8 billion people around the world, then I have 200,000 customers. And then I go from somebody working in my basement to somebody with a business. And so the access to not just Brazil, but Brazil, Argentina, Ecuador, all of the Latin American countries, I now am a business rather than a hobbyist. And third is that trust, because I buy, as a consumer, I buy from companies that I trust, that I know aren't going to steal from me, that I know are going to give me a valuable product. And so Apple and Google and Microsoft and others do a good job of curating or checking to see if does it work? Does it turn on? Is it spyware? That's something that we get in benefit. And then fourth, and Mitchell didn't hit on this, but I think it's important, is these companies provide us tools and they compete on developer tools to encourage developers to try new things. So they are spending money to build tools, not because they're nice guys. They're spending money to build tools because they want us to make the next great app on their platform. So there's still competition because they want us to build the thing that will sell their next device or their next idea or their next product. So Apple without us isn't as successful as it is today. And we have to work in partnership with them, and they have to provide us services that we want. So I thought Versteyer's quote is so wrong-headed because we've never had more opportunity than we have today.
Great, Morgan. It's a very interesting point of view. And it's an opposite of what DMA thinks about the small business, that they're not being protected. It's great. Rafael, I would like to listen. What is your visions about the lessons that we can learn if the DMA proliferates, not only in Brazil, but also in the larger South American economy? As you know, César has already told that we have a bill, the 2768, that is being examined by our Congress. It was inspired by DMA, and it's been discussed in about 2 years. It was launched in November 2022. And I would like to listen to your visions about what we can learn in Brazil.
Thank you, Bianca. Thank you for the Legal Grounds Institute and the ACT Association. Yeah, it's an awesome opportunity to be here talking to you today. It's my pleasure to join this stellar team of panelists. So I really appreciate the kind invitation. And yeah, this topic, I think it's like fascinating because as my colleagues here were saying, the panel, it's not like straightforward, right? Like I think the marketplace and the businesses surrounding apps and these ecosystems, it's way more complex than a mere relationship of like competitors or like input supplier and a client, right? Like ecosystems by definition, they are not only a supplier or a competitor, but they enable other marketplaces to exist in the first place. So I think that's what fascinates, what is fascinating and what makes this discussion very interesting. From a legal perspective, and notably from an antitrust perspective, we have been seeing this discussion on whether digital platforms should be regulated or not for quite a while. So although it is a hot topic, it's not precisely new, right? We can say like we have been having this discussion for the last 10 years, maybe. But I think that now we have moving forward to a more concrete discussion on, okay, so authorities, you want to regulate digital markets, but in practice, how are you planning to do it, right? Like, what are the effects? Because I think when the DMA first came out, or at least when the discussions surrounding the DMA started, there was a common understanding that there was only like, okay, one way of doing this type of regulation, right? Okay, so ex-ante regulation of digital platforms, what it is it about? But what we have been seeing now, and that's like, this is, I think, where we are in a very interesting momentum here, is that no, there's not only one way of doing it, right? So you have like several ways of doing it. And we have these more concrete examples that have already entered into force, like the DMA, of course, but you have also the new section 19.8 of the German Competition Act. You have the MCC in the UK, which has already been approved in Parliament and which will probably enter into force very soon. You have a lot of other bills or initiatives taken by other jurisdictions, including Brazil, but also Japan, Korea, India, Russia, Turkey, Kenya. So we can name basically all of the countries here. And the DMA, of course, since it was the pioneer, and since we're talking about Europe, right, which is a major jurisdiction, of course, it inspired most of these types of regulations, right? But I think we have to, at the same time, like analyze carefully the DMA and talking about like from a Brazilian perspective and from a Latin America perspective, I think most importantly, we have to not only kind of copy and paste this type of regulation, but actually understand what type of problems we potentially want to solve, right? I think that's what a regulation is all about. So if authorities in Brazil believe that an ex-ante regulation should be put into place, okay, but what type of problem are we gonna, like, first we have to identify the problem and then design a proper plan on how to solve this problem, right? So I think identifying the specificities of the jurisdictions, I think, is of the utmost importance, because every country has its own economy, has its own level of economic development. So we cannot compare like emerging economies or from like South America, for instance, with like Europe or the United States. So I think we have to be very careful when like talking about the inspiration that the DMA can cause worldwide. So I can go into more details a little bit of some of the provisions, but I think we can touch on these points later on our conversation.
Great, Rafa, thank you. César, you would like to ask a question to Morgan? Open your microphone.
Yes, perhaps Morgan and perhaps Mitchel could answer. I was just remembering one statement from the report of Lina Khan to Congress. I think it was about Tile. I can't remember the name of the company. They are an app supposed to find things, and they work well in the Apple platform until up to some point. And then Lina Khan said that they have developed, Apple itself has developed its own app that is supposed to be a substitute for this, I think, Tile app. So what Tile charges Apple is that after Apple has developed its own app, what happened is that they have introduced some bugs on the system that supposedly would be against a title. That's something that is in the report of the U.S. Congress. So in some sense, just to be a bit provocative on our discussion, but just to perhaps finding a counter example, or perhaps you could explain that's actually not a counter example at all, but I would be curious about what you think about it. I don't remember the name of the company. I think it's Tile something.
Yeah, it is. And it's actually an interesting example. And Lina Khan's, Chairwoman Lina Khan's presentation is provocative and a bit false. And I spend a lot of time working on this issue because it is an issue that is tied into privacy and security. The problem is, and this is true with a lot of the DMA issues, Tile allows you to have a small little thing that you can put on your stuff so that you can find it and use your phone to find it. It's nice and it's convenient. The problem is Tile can also be used by bad people to track their wives, to stalk someone that they are attracted to, but does not want to date them. And so the bugs that Apple introduced, and a lot of the things that Apple introduced, were because there was real pressure from women whose husbands maybe were beating them and then couldn't escape their house. There are some really fundamental hard issues about a hidden device that tracks you everywhere you go. And there were questions about how does that information, do the police have access to it? How does it get into it? What servers is it on? And And to be clear, I don't think Tile is an evil company or was trying to do a bad thing, but you have to confront the reality of how people behave with their phone. Do you remember earlier, Mitchell said people trust their phone and their phone is on them all the time. So part of figuring this out is, how do you create an environment that is open for innovation, but not open, but also protective against things that can cause harm, real harm, and violence against people. So in the Tile case, the problem is this, and this is why DMA is a terrible tool, is a bad fix for the problem. Tile's argument was, yes, Apple, but you can trust us, so you should give us access to the fundamental elements of the phone. And Apple's response is, well, if we give it to you, then do we have to give it to everyone? And if we give it to everyone, not everyone is trustworthy. And in some cases, I think Tile wanted access to more features and more functions that Apple was willing to give them. And there was definitely a business-to-business fight. The problem is DMA comes along and says, you must make your entire phone open for everyone. So anyone making the idea of must carry. This means maybe a company that is not so good as Tile, they also get access to all of the security elements, the precise geolocation, the networking stack, so it can report where you are. The problem with the DMA is it's a giant hammer for something that is probably a dispute between companies that's solved more with a pen than a hammer, as they can work out different arrangements. But I know from being on the inside of this fight, the biggest issues were around privacy and security. How do you give people access to the tools that allow you to track your child, your wife, your friend, and do it in a way that is safe? And Apple's argument was, we don't trust every company and we aren't going to let it happen. So I think that Tile is a great example of how difficult this really is, because it does get into these kinds of physical safety issues. And so that's part of the problem under DMA. Mitchell, I don't know if you have anything more to add. Sorry, I talked so long.
No, perfect. I agree. And it's actually like things like this that can potentially break that trust in phones that consumers have. If these stories come out there, probably not from Tile, obviously, I'm talking about someone that could jump on this technology, and especially if Apple would open something like that up and those stories would come out there, then consumers wouldn't trust me either, because it's hard to differentiate who is doing what. And like, people have their own jobs, their own life, and they're not going to research every third party. So that's what I'm saying. I fully agree. And I think that there are some safety and security features in place to make sure that the trust in the platform stays there.
I just want to add that those issues were not even mentioned in the report of the U.S. Congress. These trustworthy considerations on the very sensitive issues of finding things that you can apply it very badly if you want. So and the issue of trustworthy is really key in this, and it was not mentioned in the report, and I think it's very partial in this sense.
And again, I don't think Tile is an evil company, but I think this is the problem with the report. It had a point of view that it wanted to make, that it wanted to say. It didn't say, here's this, here's that, here's this, here's that. It said, no, there is only one way, and it is my way. And again, this is the problem. Privacy and security is important, and figuring it out is hard and will take time and won't be perfect. And that is something I think that Brazil has to take into consideration as well. Every country needs to think about how does it protect its citizens, and what does it expect from those companies that it allows to have access to the citizens, a right to privacy. Some of the security elements are important. And the DMA breaks many of those because it says anyone has access. You must provide access. And so when it says things like interoperability, does that mean I can force Apple or Google to give me access to the records on your phone? Is it simply a consent mechanism where if I click yes, then now I have access to everything? Because I don't know, maybe Brazilian grandmas are better than American grandmas, but my mom is easily fooled by text messages that say click here. So I am a little concerned that, I am sure that Brazilian moms are much smarter, but American moms sometimes they click things they shouldn't. And so I think it's important to take into consideration.
They are not, for sure. We have a lot of problems.
I would love to say they are, but I'd love to, but it's not. It's really not.
Yeah, I think it's all over the world. It's almost the same. It's really difficult to deal with digital fraud. Very interesting remarks. Mitchel, I would like to ask you, what do you think that are the challenges you may see in Brazil, but also the largest South America digital economy, if DMA-like regulation is adopted? In Brazil, we recently approved, not recently, but in 2018, we approved a data protection regulation. Now we have this bill on competition of large platforms. We have the bill of regulating AI that is in our Congress too. And so I would like, and they're all intertwined, as Morgan was talking right now about data protection, how we can preserve our privacy. So I would like to know what the challenge you may see in Brazil, but also in South America, if DMA-like regulations adopted, and also how do you think that data privacy regulations affect the development and deployment of AI in small business?
Yeah, thank you so much for the question. It's fascinating because I go to Brazil a lot. I'm half Brazilian, as a lot of you probably heard in the introduction. And when I come in Brazil, it's such a mobile first country. So it's like everyone has a smartphone. Everyone almost always just engages with digital platforms and everything through a smartphone. Obviously, there are other devices, and people might have other devices, but it's more than in the EU. It's a mobile first country. And that shows actually that it's such a big market for someone like me that is passionate about building an app and having that rolled out in Brazil. It's potentially, of course, a very big deal for someone like me. It makes me excited. Now, the flip side of that is that if you would weaken a platform like that in terms of security and privacy, the effect of it could be even more dangerous than, for example, in the EU. So one of the examples that I would like to give, and I give that a lot to friends in Brazil as well, is that sometimes I also notice that people use something like a CPF, which is a very secure number for your citizen's number, that you can use for all sorts of things. By the way, you can get a mobile phone number, you can literally engage with the government through that number, but it's also being used by some people as their address for their Pix. Pix is a mobile platform where you can send money back and forth through banking. It's a very, very elegant platform. It's very cool. But if you use very private information like that should be very private, and you can just send that through, I don't know, wherever, or maybe put that on a little billboard where you're selling stuff. It shows that that if that happens, and what we're going to do is open that further up, where other potentially malicious app developers are also going to ask for that information, then we're going to get into a territory that is very dangerous. This is just one example, but like I feel like, for example, the App Store is preventing that from happening because you have an Apple account. I don't have to process your information. I can let Apple process the payment, and actually, like I don't have anything to encrypt. I don't have anything to save other than you purchased something and your account is supposed to get whatever you purchased, but that's it. And I feel like that's very favorable for a lot of people, including Brazilian citizens, and especially for me as a small business who like having to operate all those servers and making sure it's all secure and making sure I have to store that, all store stuff like that, because people are going to expect other options and all sorts of stuff, which I feel like is another problem of the DMA, but it's also something that could affect Brazil if something similar is happening. Is people are going to expect all sorts of things from me as a small business that I can't provide. So that's one. And the thing of AI is actually also very interesting. It's his second question. One of the things that's happening here, unfortunately, in the EU right now is that many companies are actually pausing some of their AI efforts in the EU, which is actually going to impact me as a small developer as well, because, for example, something like App Intents in Apple AI is actually very interesting for me to engage or have my customers engage with my app in a new way. So I can actually tell Apple AI what the app intention should be in like communicating through Siri, and probably other platforms have are gonna have the same thing. But if that's scaled back or rolled back, which, to be fair, it's not just Apple, it's also Meta, if I'm not mistaken. OpenAI is also, they couldn't release a feature like memory for the LLMs in the EU, if I'm not mistaken. I'm not sure, but like that's I think that's true. Yeah. So we're gonna get into territory where I cannot use the latest technology to engage with my customers, and that is, like, apart from security, privacy, obviously the scale of a small business that, like me, that wants to focus on innovation, and then on top of that, I'm going to, well, have a let's say at least a lag, but maybe even not find out at all on how to use these tools for my audience here in the EU. So yeah, that's my story. So thanks for that.
Great.
I think
So, okay.
if I could add something to Mitchell, what he said, which was brilliant, is he is describing a world where these companies, the Metas, the Apples, and others, are competing to provide services. And my concern is, if you get the DMA world, you get companies competing to comply. So their focus will be, how do I comply with the law? Right now, their focus is, how do I make the better AI tool that will win customers? And I think that what Mitchell said about how he is looking at AI is, to the small business, it's everything. Because if I have Meta and Apple and Amazon and OpenAI and Perplexity, and everybody is offering different spins or different ideas, I get to choose, how do I build a product using those services? If the focus of the companies is now, how do I comply with the law, rather than how do I build great products, we know what that looks like. When people focus on complying, they hire lawyers. When people focus on competing, they hire developers.
And it's very important to Brazil, these lessons, because you have a lot of lawyers. Maybe we are the country in the world that has more lawyers. So
lawyers are people too. They're not bad people.
But they're seeking for jobs and things to do. So regulation.
Morgan, I disagree. I disagree.
I disagree also. I'm a lawyer, but I'm also an economist, so I can talk. So very interesting. And Morgan, I would like to ask you a question, and then I will throw a question for all of you, because we're discussing the how regulation can improve competition. So I would like to know, how has DMA affected the ability of developers to work on their creative ideas? And also, how do you think that competition regulations improve market accessibility for new and independent app developers? If not DMA, what?
So at some of this will go to Rafael for a good answer too. But let's start with your first part. At this point, DMA is still in the implementation phase. And so we are working with the European regulators to ensure that there are things like that platforms have the ability to block dangerous apps, right? Back to Mitchell's point. So we have to meet with the regulators because they have not yet fully implemented DMA. It's interesting that one of the concerns now is, and this gets back to my point about compliance, Apple presented how they want to comply, and it shifts costs in ways that I think a lot of developers are going to find difficult. So right now we're still fighting over implementation. What does it look like? And again, my apologies to you, Bianca, and other lawyers, but it is rooms full of lawyers now instead of rooms full of technologists, and we're still at that implementation phase. Mitchell pointed out the first real damage from the DMA, and that is around access to AI tools, to large language model tools and AGI tools. This is the first DMA downside. And I think what was very interesting was when Madame Versteyer was asked about this, her quote was, "Well, I didn't want it anyway, and I would have said no." And that was her literal response was, "I would have said thank you, no, thank you very much." So her perspective was, "Oh, I don't mind that Apple isn't providing it because we didn't want it anyway." And as Mitchell pointed out, that is not the voice of the average consumer. That is the voice of a person who is at a different stage in their life than a consumer who is looking for what can make my life better. And the thing that's interesting about the AI usage is it's not like in the movies. The way that you can use AI is to have it look at all of your last 3 years of bank records and say, what could I do better? Do I need to pay this off? Or if I am a small business, I may want to look at that and say, would I make more money if I paid my suppliers on time? Or looking at my books and saying, oh, I hold on to my merchandise too long. Maybe I need to sell it sooner. So you can use AI on a mobile device to help you manage the things in your business that you aren't necessarily good at. Maybe you have a business that sells to bigger businesses. And so you have to write things that are called, that are responses to RFPs, right? So a company says, we are putting out a bid for building this building and we need this supplier. Well, I can build you an AI tool to look at all of your past times that you have bid on something. You have offered, made an offer of a contract. And I can say, what are the best elements out of that? And now I can automate it. So instead of you staying up late with 4 cups of coffee to try to write the next one and the next one and the next one, I can give you with AI an almost complete RFP based on your own words. And then you just have to edit it and send. So now, instead of only bidding on 1 job a month because it takes so much work, you bid on 6. And maybe instead of winning 1, now you win 2. And now you hire 3 more people. And these 3 more people help you bid on 2 more. So the use of AI and why Versteyer's comment is so dangerous is she is looking at AI as though it's a movie. And Mitchell and I are looking at AI like it's real life, right? How do I help on those small things that I can make better with intelligent systems doing the boring work better than I can do it? Mitchell, I don't know what you think, but that one to me is a big one.
If I just may add something here, sorry to mess around with the others here, but I think what Mitchell and Morgan just said, I think it's very important because it highlights what are the adverse effects of implementing this type of regulation, right? Which all relates to innovation. And notably, if you implement this type of regulation without taking into account a country's specificities, this may be even more troublesome. Like, for instance, in Brazil, Brazil has been developing like a vibrant and emerging tech sector in the last few years, a decade or so, due to both public policies and also private sector initiatives. So I think the risk for Brazil is if you implement a troublesome type of regulation, this can, in practice, like backlash. This can like undermine all of these efforts that both private sector and public policies themselves are putting into place to foster our economy. So I think this is something that we really have to be cautious about here in Brazil before just implementing a regulation just because other countries are doing. So our like competitive landscape is totally different. Like we have a lot of Brazilian companies in the tech sector, so we do not only have the multinational companies. You know, like there's some interesting data. For instance, like the number of unicorns in Brazil went from 0 to 35 from 2016 to 2022. So in 2016, we didn't have any unicorns. And like 6 years later, we have like 35 unicorns. But there's still a lot of room for improvement. So like a study by the OECD showed that Brazil spends less than most OECD member countries in R&D. Brazil spends roughly 1.5 of its GDP in R&D, while China spends double of it. So I think we have to be very aware of all of these obstacles that Brazil has to overpass, and adopting a regulation without thinking it clearly may be very bad for businesses and bad for our economies more broadly, and in the end of the day for consumers. And as we all know, public policies such as competition policies, they aim to protect consumers.
Mitchel, you want to compliment?
Yeah, no, I agree, and I found it actually very, very good what Rafael and Morgan were saying. And one of the things that is very beautiful put is like viewing things as a human being, and seeing how things are used by human beings. It's quite different than how some of the statements that Verstager has made a couple of times, at least how I interpret her statements. I think there's a very big difference between how we use things and how she's bringing things out, at least in the statements that she's putting out there. And it's very hard for small businesses to get our voice in, which is something that I want to thank ACT for, because of them we are able to. But this is something that I feel like Brazil also has to be careful for with. Is listening to 1% of the businesses that are in Latin America, that, with all due respect, they're very successful, and I love that for them. But it's hard to just make policy that only let's say is listened to from 1% of the businesses, which is also what's happening here in the EU. Very big market players that are complaining about certain things. And already own about 60% of a certain industry, especially here in the market of the EU, and policy is kind of being shaped. If you look at the statements, if you look at certain posts on X as well, where they're literally mentioning those companies, it makes it feel kind of weird for me as a small business owner that some of these policies are still being pushed in my name, our name, as small businesses, as consumers. Whilst whenever it's actually being announced, whenever the enforcement is being announced and it's being posted on X or somewhere else, we're again talking about this very big corporation that is, with all due respect, perfectly capable of litigating their own cases with Apple, Google, Microsoft, whatever they want to litigate. And but eventually it's all still for consumers and all still for small business owners, quote unquote. And that is stuff that I find difficult with the EU, and I hope Brazil is going to take a different approach and actually listen to the small business owners that they're trying to defend in this case. Yeah.
Great. I definitely agree with you, Morgan, that we have too many lawyers in the room. Of course, we have to have the lawyers, but we have to have more economists, developers, computers, engineering, technical people, and also in Brazil, it lacks on our discussions on AI regulation and competition regulation for sure. César, you want to ask a question?
Yes, I think a key issue in both sides of the Atlantic is self-preferencing. It's has a very remarkable position in the conducts, on the evil conducts of DMA, and it's quoted a lot of times on Lina Khan's report. I think that, well, it would be a subcase of the antitrust case for vertical foreclosure. Is if you're increasing your position for adjacent markets, it's supposed to discriminate against some competitors. They're supposed to be in other part of the network. So how do you think that DMA, this sort of initiatives, legal initiatives, could impose obstacles to self-preferencing? Because in some sense, most of the enlargement of those companies is in some sense for adjacent markets. So if you forbid it in a per se rule, for me it seems very restrictive for their enlargement and for their development. So what do you think? How should we treat self-preferencing in these digital markets?
Well, I think one of the issues, again, is the problem with DMA and legislate and laws like it is it's too big a weapon. It's a giant brick instead of something small, because of course we should always, pay attention to abuse of self-preferencing. But I'll give you an example. I don't think it's a good idea to have a phone that comes out that has no camera, right? And that you have to then download separate software to make the camera work. So that means, and the same with the browser, right? If it doesn't have a web browser when you buy it, that's a nightmare. And I think about the camera as a good example. When Apple first came out with the iPhone, the camera wasn't very good, and the filters were terrible. And then an app came along called Camera Plus, and it was made by a small developer. And it was better tools, better user interface, better in all ways. And we all bought it. We all bought Camera Plus, even though the phone self-preferenced for having its own camera. Why? Because Camera Plus was better. And then came along Snapchat, and it added filters. And then Camera Plus didn't have the same filters. And so now everybody was in a race to build new filters. And then TikTok did filters, and so on and so on and so on. And you had real competition, even though every phone ships with a camera. Why? Because Apple's camera app wasn't very good. Now, here's the beautiful part for a consumer. Apple's camera app today is a lot better than it would have been if it wasn't for Camera Plus and Snapchat and Adobe and everyone else. So they had vibrant competition. Right now, today, absent the security and privacy stuff Mitchell and I talked about earlier, I can still get my camera app on the Apple App Store. And it shows up. If you do a search for camera app, it will show up. You're not precluded from being on the Apple App Store. So I can build a better product, and I have just as much space on the store as anyone else does, the big company and the little company. And that's in a world in which Apple builds a camera app into every phone. And so I think we have to be really careful and go case by case on self-preferencing. and not look at it like every instance of a company putting a tool in from the start is somehow bad. And I think that's the problem with DMA, is it makes the assumption that if your phone comes with a camera, the company must be doing something to forestall competition in cameras. The reality is, I need the starter camera, then I want to do, I think, and then you can make better cameras. I don't know what Rafael and Mitchel think.
I think this,
Yeah.
Please go ahead.
No, I think this is actually very correct. And what is also very important, and I think Morgan also said something like that, is that whenever a company like Google or Apple builds an app like that, it brings attention to that segment, and it makes sure that if you want to compete, well, I mean, you can get on the App Store and make sure that you are competing, because people are going to look for alternatives themselves if they want to. So it's bringing a lot of light on the segment, and this has happened with all sorts of companies, obviously, which is actually beneficial for us because, well, we can compete there, whilst the marketing, if you will, and also the distribution is being handled by Apple, Google, Meta, Microsoft, stuff like that. Yeah. So.
Yeah, I think the issue is that like the DMA was clearly inspired from actual cases in Europe, right? Like actual investigations. And for instance, on self-preferencing, the obligation is clearly inspired by that Google shopping case. But the issue of the DMA is that once like a company is considered as a gatekeeper, it has to comply with this set of obligations, right? And the DMA does not allow for rebuttals based on efficiencies. So in essence, what the DMA is saying is that these obligations, they are illegal per se, right? And as Morgan was saying, like that's not always the case, you know? Like I think it's way more complex to this type of conducts. They are way more complex, and their effects are most of the times twofold. Sometimes they can be pro-competitive, and so I think not allowing this type of rebuttals, this type of efficiencies defenses, I think that's something that is it seems like very harsh. For instance, like the MCC and the new Section 19A in Germany, they allow for this type of rebuttals, you know. So I think they're not taking that like that rigid approach. They're more flexible in terms of understanding case by case whether that specific conduct is illegal or not. And I think since these conducts and these markets are very dynamic, very complex, I think we should look carefully into taking these more flexible approaches.
Great, we are running out of time. Actually, we had passed the 2 minutes, but I would like to ask one last question from the public. How do competition policies and enforcement practices differ between Brazil and other major jurisdictions, such as the US, European Union, and other Asian countries? And if does harmonization help or potential hinder technological advancement? I was thinking right now that maybe we will have tax, like we have tax havens, maybe we'll have regulations havens for people to develop more easily.
Well, I'd love to have Rafael's perspective on this, but I will say one thing that's important. All of the gatekeepers initially listed under the DMA just so happen to not be European companies. So my concern with your example is that countries act in a self-interested way. And so when they pass their version of a DMA, it is going to be built to make sure that it punishes companies not from their homeland, but from elsewhere. And if everybody does that, then we end up with a basically trade barrier world where, I mean, you saw it, right? Europe is behind on AI. So what are they saying? Oh, well, we'll slow AI down. Brazil is, you know, we use the term BRIC, right? It's the B in BRIC. It is one of the leading countries with an expansionist ability for its economy to really be one of the major players around the world. So if everyone else is writing laws that make it harder to break in or to compete with their domestic companies, you're not going to have a very open environment. So I think the harmonization problem is everybody thinks they're harmonizing, but what they're really doing is protecting, and they're protecting their domestic businesses. Rafael pointed this out. One of the companies that was really complaining a lot was Spotify. And it's funny to say that Spotify is some small business just trying to get by. It's the largest music streamer in the world. But they were successful in saying, well, the American company, Apple, is mean to us and doing mean things, so we should punish them, even though Spotify is much bigger than Apple in terms of total number of users. So in that regard, you see what happens with DMA laws. Even if they harmonize, they get enforced in a way that protects domestic businesses. And Brazil is in an expansion phase where you are doing more and growing around the world. And if the rest of the world is in a close the doors phase, that's not good for Brazil.
Rafael.
Yeah, I think in today's economy and digital economy, mostly it's a global economy by definition, right? By nature. So jurisdictions, they are in this global dispute for attracting investments, as Morgan was saying. So there is this risk of you implementing this kind of barriers. So competition policies, one thing is what the law says, and what the other thing is how it is enforced. So I think if you have similar types of rules, this can be good, but countries differ a lot on how they enforce this type of rules. So in Brazil here, for instance, courts do not intervene that much when it comes to competition policy, and in the US it's totally different, right? Cases have to be brought before the courts by the FTC or the DOJ. So it's very different. So I think this is only reinforces what we were saying here, I think, for this past hour, that there is not a magical recipe, and I think countries have really to reflect on the path they want to adopt, and mostly why they're taking this approach, right? What kind of solution they're seeking, what kind of problem they are identifying. And I think one thing that is interesting to highlight is that in addition to the bill 2768 in Brazil, we had recently a big consultation undertaken by the Ministry of Finance regarding regulation of digital platforms. Over 300 comments were received by the Ministry of Finance. They are public, whoever is interested in taking a look. And CADE itself submitted its own comments. And it was in my view, my humble view, a very groundbreaking comment, because it was the first time that the Brazilian Competition Agency said loud and clear that the traditional tools that the agency was using may not be enough to address all of the competition concerns, in the authority's view, related to digital markets. That's one side of the story, but on the other hand, I think CADE's comments were very solid and sober, let's put it this way, because it analyzes this types of regulations that has been taking effect abroad, like the DMA, and it emphasizes the need for doing a very, very careful analysis here in Brazil before implementing these rules. So I think even though there was this acknowledgement that, okay, there is this need maybe of implementing this type of rule, we need to very, very think before implementing it. And for instance, implementing AIR, right, which is regulatory impact analysis, which is something like a legal instrument here in Brazil that we have, that agencies, regulatory agencies have to follow before implementing a groundbreaking rule. So this, I think, involves a very, very clear message that we need to conduct a very deep analysis before implementing this type of rules.
Great.
Yeah, and
Mitchel, do you want to make closing remarks now? Okay.
yes, I will keep it short. Something that Morgan also said that, and Rafael also touched on, is like the regulation is very heavy. DMA is like a hammer, which does what it feels like, because it's not only just for innovation, it's also for our talent that is leaving the EU. It's also for startups, scale-ups that are leaving the EU, for example, for the United States or other places where they feel like they can innovate more or faster or better. Because it's right, and what we want to prevent, and I hope we can still prevent that in the EU, is that is going to get worse. It's limiting us as small businesses and small developers from using the tools and the new innovations and the new things that are coming out to build EU hopefully tech giants. That would be very cool, but then we need those tools, and if we're going to almost like scare away the talent, scare away the startups, scare away the scale-ups, then that is only going to get worse. So and it's a byproduct of regulation like the DMA, and I if you look at incredible apps in Brazil, like the story of iFood is something that I find very interesting. And and there are many other giant competitors that try to get in, but iFood is still very strong in that competitive market of Brazil. And you have many examples like that. I hope the next iFood will get that opportunity as well, get the same IP protections as they had in the beginning in the App Store, and all that stuff. Yeah, it's very important for the next unicorn, sorry, and the next iFood to come to remain in Brazil. Thank you.
Great, Mitchel. Thank you, everybody. Thank you, ACT, the App Association. Thank you, Morgan, Mitchel, Rafa, and César to be with us today. We have a lot of questions from the public, but unfortunately we run out of time, so maybe we can have another webinar on the theme. And it was a great discussion. It's really important to debate how regulators can ensure that competition policies do not inadvertently stifle innovation within the digital and AI sectors, and also what role do small businesses and startups play in driving innovation under a regulated digital market framework that we see all over the world. Thank you, everybody, and have a great weekend. Bye-bye.
Thank you so much.